Welcome to the Indiana Legal Review Podcast. Today we've got a great show because we'll review Indiana Risk Assessment System, or IRAS-PAT, and Wayne T Szulkowski, Ashlyn Perigo's attorney of record. Was he effective or not? Let's go.
Right. Let's unpack this. We are diving deep today into, this critical intersection of criminal justice reform, the kind of cold logic of these standardized risk assessment tools, and the absolutely non-negotiable role played by competent legal representation.
Right. That intersection is really where theory slams into the brutal reality of the courthouse floor, isn't it? I mean, in principle, the system should guarantee rights, but in practice, those rights are only as strong as the lawyer who's supposed to be defending them.
Absolutely. And our mission today is to really analyze one single, quite sobering case study, the legal representation of Ashlyn Perigo. We want to understand the devastating, just cascading real-world consequences that happen when an attorney's performance just utterly fails to meet the basic procedural demands of the modern judicial system. We're talking specifically about Indiana here.
Yeah, we're really scrutinizing the high cost of incompetence in this situation. This is a deep dive into the specific failures of one attorney, Wayne Szulkowski. We're tracking how seemingly simple, maybe preventable mistakes by counsel cost his client not just, legal leverage, but weeks of her freedom. And it ultimately led to new, serious felony charges down the line.
And we should definitely note that this deep dive is heavily informed by sources like Legal Analysis and some pretty hard-hitting conversations hosted by the Wabash Watchdog News magazine. They've got that tagline, "The Cure for Conspiracies," right? And they're doing really vital work tracking justice and reform, particularly around Indiana's bail system and this Indiana Risk Assessment System, the IRAS.
Yeah, and the central figure here, Szulkowski, he came under immediate and frankly severe scrutiny after his case filings revealed these really fundamental, almost embarrassing errors. We're looking at a situation where arguably the failure to just proofread a document set a whole chain of events in motion that just radically altered his client's life.
It's pretty staggering when you put it like that. All right, so before we can really judge the attorney's failures here, we have to understand the procedural environment he was operating in. Indiana tried to reform its bail practices, right? Implementing these strong mandates for pretrial release, mostly driven by something called Criminal Rule 26. So what's the philosophy behind Rule 26? What does it actually tell courts to do?
Well, Rule 26A represents a huge philosophical shift, really. It pushes towards presumptive liberty. It dictates that if an arrestee does not present a substantial risk of flight or, danger to the community, the court should release them.
Should. That's the key word.
Exactly. Should. And this release, ideally, must be without money bail or surety. It should only be subject to the least restrictive necessary conditions to ensure they show up and stay out of trouble.
Okay, so pretrial detention or demanding cash, that's supposed to be the last resort, reserved only for specific evidenced risks. When can the court actually detain someone or set a really high cash bail under Rule 26?
There are three pretty clear statutory exceptions. They're listed right there in Criminal Rule 26A, sections 1 through 3. First, the most obvious one, if the person's charged with murder or treason. Can't really argue with that one.
Right.
Second, if the person is already out on pretrial release for another separate incident, that suggests, they might have already shown some difficulty complying with court conditions.
Makes sense.
And third, if they're currently under some kind of formal state supervision, think probation, parole, or community supervision.
Okay, those three buckets, they seem to represent pretty clear established risk factors. But if you're outside those exceptions, the court has to do an individualized assessment. And that brings us to the heart of the state's reform effort, this IRS system.
Precisely. Rule 26B requires courts to use an evidence-based risk assessment tool, specifically the IRA's pretrial assessment tool, or IRA's TAP, to figure out if that substantial risk of flight or danger actually exists. It's supposed to take the guesswork out of it.
Okay, let's break down the IRAS-PAT then. How does this, clinical standardized tool actually work? What factors does it look at most heavily to get that score?
So the IRAS-PAT, it's a standardized analysis based on 7 factors. It's entirely backward-looking, relying heavily on historical data points. Things like basic demographics play a small role, but the core predictive factors are really tied to prior criminal involvement.
Like what specifically?
Things like the age at first arrest, the number of times someone's been incarcerated before jail or prison, and any prior failures to appear in court. Those weigh pretty heavily.
Why is that agent first arrest factor considered so important in these kinds of risk assessments?
Well, actuarial science suggests that getting involved with the criminal justice system early is a pretty powerful predictor of continued involvement later on. The younger someone is at their first arrest, statistically, the higher their long-term risk profile tends to be. The system is essentially trying to quantify that trajectory. And crucially, the IRS also looks closely at stability factors, employment, where you live, how stable that is, and significantly, any history of drug use in the past 6 months or evidence of a severe drug problem. These 7 factors get crunched together into a score.
And the scores are?
Low risk is a score of 0 to 2, moderate is 3 to 5, and high risk is 6 or more.
So a high score theoretically means the court needs to impose tougher conditions, maybe, but the law doesn't force the judge to just blindly follow that score, does it?
No, and that's where it gets complicated and frankly, often pretty controversial. According to the Indiana Court of Appeals, courts are allowed to consider other relevant factors beyond just those 7 things measured by the IRS-PAT. The assessment tool itself, it's explicitly designed to inform the non-monetary conditions of release. Things like electronic monitoring, maybe mandatory check-ins. It's not necessarily meant to be the sole decider of detention versus release.
That flexibility, that wiggle room, that sounds like exactly what critics would latch onto. But before we dive into the criticisms, we have to acknowledge the data, right? The sources we looked at suggest the IRA's-PAT is actually pretty effective, statistically speaking. How strong is the evidence for it?
Well, studies, including pilot programs run in several Indiana counties, they do show the IRA's-PAT has what they call good to excellent predictive validity. If you look at its power to predict new criminal activity, it scores around 0.67 on that 0 to 1 scale.
That sounds pretty good for predicting human behavior.
It is, yeah. And for predicting failures to appear in court, it's even a bit higher, about 0.71. For a behavioral prediction tool, those numbers are considered pretty robust. So advocates argue, quite strongly actually, that it replaces these arbitrary decisions that might be based on a judge's personal opinions, biases, or even political considerations.
Okay, so if it's statistically strong, what's the core problem that critics like Megan Guevara, who is mentioned in the sources, raise? What's the fundamental issue?
The critique really centers entirely on systemic bias. It's that old garbage in, garbage out problem. Guevara and others argue that because the input data itself, prior arrests, prior rearrests, is generated by a system that already shows significant racial disparities.
Right.
The assessment tool simply ends up quantifying and, perpetuating that systemic racism. Is certain groups, say black men, are statistically more likely to be arrested and charged for the same behaviors as, say, their white counterparts, then the algorithm, by using that historical arrest data, naturally assigns them higher risk scores, unfairly.
So the tool reflects the bias already in the system.
Precisely. And critics argue judges then misuse those inflated scores. Instead of just using them to set non-monetary conditions like check-ins, they use them to justify imposing money bond or outright detention, which kind of defeats the purpose of the reform.
It becomes a sort of self-fulfilling prophecy of historical injustice. Okay, now let's focus on one really crucial safeguard built into this system, Rule 26D. This seems to highlight just how critical sticking to the procedure is for the defense. What protection does 26D offer?
Rule 26D is a huge constitutional shield. It mandates that any evidence derived from statements an arrestee makes, specifically for the purpose of preparing that IRA's assessment, is explicitly not admissible against them later on, not in civil proceedings, not in the criminal case itself.
Wow, that's extremely powerful. So you can basically be honest about things like drug use or maybe unstable housing during the assessment.
Right.
And the state can't just turn around and use that admission to prove you're guilty in the main trial. Why is that specific immunity built in? Why is it necessary?
It really serves 2 critical purposes, both rooted in constitutional concerns. First, it directly addresses the Fifth Amendment right against self-incrimination. I mean, without that protection, the assessment just becomes a compelled warrantless interrogation, right? No defendant would ever answer truthfully. Second, the courts actually need accurate risk data to set appropriate, truly necessary release conditions. So by granting this immunity, the system encourages honesty, encourages candor, which helps ensure the court gets a full, accurate picture of the defendant's actual risk profile. The exceptions are super narrow, like it might be used in pretrial proceedings related to release conditions or if fairness absolutely demands it, but Generally, if the state breaches this rule, they've potentially tainted their whole case.
So this legal protection is paramount. It just underscores the absolute necessity for a competent attorney who knows exactly when and where these protections apply and how to enforce them.
Absolutely. It's a complex tool that requires skillful handling.
Okay, now we transition from the demands of the system to the failures of the professional who was tasked with navigating it.
He fumbled the motion, the plea fell flat. My girl could've walked, now she's sitting where she sat. Wayne read the code like it's gospel wrong. Now the courthouse hums a name and a song. Wayne, you fumbled the motion. Wayne, you drowned the notion.
Ashlyn Perigo was arrested back on September 9th, 2024. And the charges were serious. Level 5, felony possession of methamphetamine, Level 6, felony unlawful possession of a syringe, and also a Class C misdemeanor for paraphernalia. We're talking high-stakes drug charges here, where suppressing the evidence is often, pretty much the only path to winning.
Exactly right. The entire case likely hinges on challenging the constitutionality of the search and seizure. That motion to suppress. It's arguably the single most important document in a drug possession case like this. It demands absolute precision.
And Szulkowski, who was retained counsel, we should stress that, not an overworked public defender juggling hundreds of cases, made an initial, fundamental, and frankly almost unforgivable blunder in that critical motion. What was the error?
The motion to suppress critically misstated the primary charge. Instead of correctly identifying it as Level 5 felony possession of methamphetamine, the motion he filed incorrectly stated she was charged with dealing methamphetamine.
Dealing, not possession.
Dealing. It's not just, again, a minor clerical error or getting the felony level wrong. It's a failure to understand the fundamental accusation against his own client.
And that's a massive difference, isn't it? Dealing carries totally different legal weight, public perception, sentencing possibilities, especially compared to simple possession, particularly in Indiana. Why is confusing those two so profound?
Well, dealing implies commercial intent, trafficking, a much larger operation, and frankly, a massive perceived threat to public safety. It often carries much stiffer penalties, maybe mandatory minimum sentences, and it fundamentally changes how a judge might view the defendant's risk profile for pretrial release. So by filing a motion to suppress evidence in a dealing case when the actual charges were only for possession, Szulkowski basically broadcast that he either didn't read the charging information carefully or maybe didn't understand the difference.
And this wasn't just kept quiet, right? This
Right.
error was exposed publicly during that Wabash Watchdog panel discussion we mentioned.
Panelist Jimmy Clayton, whose later legal memo is a key source for our analysis, openly attacked the representation right then and there. He basically asked, exactly, what kind of representation screws up something that basic?
Ouch.
You see, the system is complicated, and I was working with what I had. It completely failed to justify such a foundational mistake. It inspired zero confidence.
Yeah, you can imagine.
And that's where you see the emotional toll. The sources cite someone, presumably the client, or maybe someone acting on her behalf like Clayton, expressing just profound anger. The quote was, "I'm extremely pissed. This guy promised the world. I don't even think this man can read. Hell, I don't think he even cares. He's a con." I mean, when you pay a lawyer for expertise, for competence, and they make a mistake that basic, the trust just completely evaporates. Okay, let's walk through the timeline of this liberty violation. It sounds critical. Right. So Ashlyn was arraigned on September 19th, 2024. At that hearing, the magistrate set bail at $5,000 surety or $500 cash. Okay, so far so standard. That fulfills the financial requirement part under Rule 26. But then the court added this crucial, very restrictive condition. She had to be placed in Tippecanoe County Community Corrections TCCC work release pretrial detention.
And in imposing that restriction, the magistrate made a direct legal error, didn't they? A statutory violation.
A huge one. The court completely failed to articulate any reasons whatsoever for imposing that work release condition. And even more critically, the record shows the court never referenced or made any findings based on her IRAS-PAT results. That's a direct violation of Indiana Code Section 3533.83.2 and Criminal Rule 26 itself.
So the order was flawed from the start.
Absolutely. This arbitrary condition, lacking any stated statutory justification, made the order legally defective right out of the gate. Rule 26 demands that any non-monetary conditions have to be the least restrictive necessary to ensure appearance and public safety. Without mentioning the IRAS score or giving any individualized reasons, there's no way to know if work release was necessary, let alone the least restrictive option.
Okay, so the order was bad. Then the situation got even worse because even when she met the financial requirement, the bail amount, she still wasn't released.
Exactly. Bail was posted on September 26, 2024. All the financial obligations were settled. Under Indiana law, theoretically, she should have been released immediately at that point, but she wasn't. She remained incarcerated simply because the TCCCC work release facility was overcrowded. According to an intake officer mentioned in the sources, the facility was on a freeze for work release.
So she was being held not because she couldn't pay, not because a judge found her a flight risk based on evidence, but purely because of a lack of bed space, bureaucratic gridlock.
Pretty much. Bureaucratic failure. And this is where Szulkowski's delay becomes absolutely catastrophic. She's being held unlawfully, clearly unconstitutionally at this point, and the clock is just ticking.
What did he do? Or not do?
He did eventually file a motion to modify bond to try and address this continued detention. But, and this is critical, the hearing for that motion wasn't scheduled until over 2 weeks later.
2 weeks? When your client is being held illegally after posting bail.
Exactly. That demands an emergency hearing. Same day, next day at the latest, you go straight to the judge. Szulkowski's failure to push for that immediate relief, his failure to convey the urgency, allowed her unlawful detention to just drag on for days, maybe weeks. She was essentially being punished for a systemic overcrowding problem, compounding the magistrate's initial error in ordering work release without justification.
And this period of continued unlawful incarceration, this is what directly led to the new level 6 felony charge, failure to return to lawful detention.
Precisely. That's the tragic outcome here. Ashland was eventually transferred and placed into the TCCCC work release program, but shortly after, she removed her ankle bracelet and didn't return. As a direct result, she was charged with that new felony on December 2nd, 2024.
Okay, now the subsequent defense memorandum, the one written by Clayton, seems pretty clever. It pivoted entirely to attack the foundation of that second charge, right? Arguing that if the initial detention itself was unlawful, then the failure to return charge simply can't stick. What are the specific legal pillars holding up that unlawful detention argument?
Yeah, it's a strong argument with 3 main legal legs, all stemming from Szulkowski's failure to act swiftly against that initial flawed work release order.
Okay, leg 1.
First, the IRAS statutory violation. Like we said, the magistrate just ignored the law, IC Section 3533, 8-day 3.2, by failing to reference the IRS or give any reason for the work release condition. That made the detention order arbitrary and legally defective from the moment it was issued.
Got it. Leg 2.
Second, the de facto denial of bail, an 8th Amendment violation. Ashland had met the bail requirements back on September 26th. Holding her past that point violated her explicit right to bail under Indiana Code Section 35-3-81. And this continued detention, despite meeting the financial conditions set by the court, arguably violated the 8th Amendment's prohibition against excessive bail. The memo cites the key Supreme Court case, Stack v. Boyle.
Okay, let's pause on Stack v. Boyle. Just remind us, what's the core principle from that case? Why is it relevant here?
Stack v. Boyle established a fundamental principle. The purpose of bail is purely, solely, to assure the defendant shows up for trial. Bail set higher than what's reasonably necessary to achieve that specific purpose is excessive under the 8th Amendment. So in Perigo's case, the argument is, once she posted the $500 cash bail, the court said, the state's stated purpose assuring her appearance was met. Holding her hostage to TCCC overcrowding after that point wasn't about ensuring appearance anymore. It amounted to preventative detention, basically punishment before conviction, without the required judicial finding of extreme risk, which Stack v. Boyle explicitly forbids.
Okay, makes sense. And the third leg of the argument?
The third leg focuses on due process violations, both substantive and procedural. Substantive due process, citing another major case, United States v. Salerno, requires that any pretrial detention conditions can't be arbitrary or excessive in relation to their legitimate governmental purpose. Arbitrarily imposing work release without any IRA's justification arguably failed that test.
And procedurally?
Procedurally, referencing Matthews v. Eldridge, Ashland was denied due process because she didn't get a timely hearing or even an explanation for why the work release condition was supposedly necessary. She was deprived of her liberty without a meaningful opportunity to challenge the grounds for her continued custody after posting bail.
So all these violations, the IRS screw-up, the 8th Amendment issue, the due process problems, they all feed into that critical legal defense for the new charge, that her initial detention was simply never lawful to begin with?
Exactly. That's the linchpin. The defense argued that the Indiana statute, IC Section 4544.1334, penalizes failure to return to lawful detention. Since the magistrate's original order imposing work release was arguably void from the start because it didn't comply with constitutional and statutory requirements, like referencing IRAs and respecting Stack v. Boyle, she was never legally in lawful detention when she was placed in that TCCC facility.
And there's precedent for this kind of argument, that if the initial confinement is illegal, an escape charge fails.
Yes, the defense relies heavily on established precedent from other jurisdictions. Cases like Commonwealth v. Garcia and People v. Quintero basically establish the principle that an escape or failure to return charge cannot stand if the very foundation of the initial custody was fundamentally unlawful or unauthorized by law. A state can't essentially criminalize someone for violating an order that the court itself lacked the proper legal authority to make in the first place.
So Szulkowski's negligence, the delay in challenging that arbitrary work release condition, it didn't just prolong her time inside.
No, it allowed the client's whole legal situation to deteriorate. It arguably created a scenario where she felt compelled to escape a form of custody that she likely believed, and the subsequent legal analysis suggests correctly believed, was illegal.
What a cascade of failure. Okay, let's shift back then to the original charges, the drug possession and the suppression issues that Szulkowski initially bungled with the basic factual error in the motion. The depth of the defense that should have been mounted here seems significant. It involves some pretty sophisticated Fourth Amendment challenges. We need to detail exactly what legal principles a competent lawyer would have been fighting for the arguments that Szulkowski's initial errors put in jeopardy.
Right. This part is almost like a masterclass in what a strong Fourth Amendment defense in a drug case can look like. The core goal, obviously, was to get the meth and paraphernalia suppressed, thrown out, based on an illegal search. The defense strategy outlined in Clayton's memo had two primary constitutional tracks. First, challenging the warrantless search itself, and second, challenging the state's ability to prove she actually possessed the drugs, even if the evidence was allowed in.
Okay, let's start with the warrantless search challenge. The police got into the room based on consent, right? Consent from Kristen Perigo, the leaseholder. Why did the defense memo argue that consent was constitutionally invalid?
The main argument was that Kristen Perigo's consent was coerced, which violates the standard set way back in Schneckloff v. Bustamante. Bustamante says consent has to be voluntary, totally voluntary, determined by the totality of the circumstances, and free from any coercion, explicit or implicit. The sources suggest Kristen only gave consent after something like 20 minutes of pressure from two female friends who were apparently with the officers or acting on their behalf.
20 minutes of pressure?
Yeah. So a competent attorney argues that this prolonged, sustained pressure, potentially involving subtle threats or intimidation, just completely negated the voluntariness required by the Fourth Amendment. It wasn't freely given consent anymore.
Okay. And even if you assume, for argument's sake, that Kristen's consent was voluntary, Ashlyn, the client, she still had her own Fourth Amendment right to privacy in that room, didn't she? Even though she wasn't the leaseholder.
Absolutely. That's the next layer. The defense argued that Ashlyn, because she was a frequent overnight guest and kept belongings in that room, had a legitimate expectation of privacy. The key case there is Minnesota v. Olson. You don't need your name on the lease to have constitutional protection against unreasonable searches in a place where you regularly stay, where you sleep, where you keep your stuff.
Right. So Kristen's consent doesn't automatically override Ashlyn's privacy rights, and that leads to the argument about conflict of consent based on Georgia v. Randolph.
Exactly. The Georgia v. Randolph argument is potentially very powerful here. Randolph essentially holds that if two people share authority over a residence, one person generally cannot consent to a search if the other co-occupant is present and objects to the search. Now, even if Ashlyn wasn't physically present right at the moment Kristen supposedly consented, the defense could argue a couple of things. First, that the initial coercion tainted Kristen's consent anyway. And second, because Ashlyn was a recognized occupant with privacy rights, Olson, the police couldn't just rely on Kristen's potentially coerced consent to barge into a space where Ashlyn also had rights. They likely needed a warrant, or at least proof of truly voluntary consent from someone with authority, which the defense argues they didn't have.
So you combine the lack of voluntary consent under Bustamante with Ashlyn standing as an occupant under Olson and Randolph. That gives the defense multiple strong constitutional challenges to the search itself.
Multiple mutually reinforcing challenges. A good lawyer layers these arguments.
Okay, but what if, despite all that, the suppression argument failed? What if the judge let the evidence in? The state still had to prove Ashlyn actually possessed the drugs, right? This brings us to the second pillar, challenging constructive possession.
Right, this is the critical fallback position.
and it relies heavily on specific Indiana case law. Even if the meth and syringe are admitted into evidence, the state still has to prove two distinct things for constructive possession, according to cases like Henderson v. State. One, the defendant knew the contraband was there, and two, they had both the capability and the intent to exercise dominion and control over it. And proving that intent and control is extremely difficult when drugs are found in a shared space.
How does Indiana law make it hard for prosecutors to prove control in a shared environment like that room?
Well, Indiana courts, citing cases like G v. State, are very clear. Mere proximity is not enough.
Yeah.
Just being near drugs isn't the same as possessing them legally. The meth here was found in a shared space, a room accessible to multiple people, including Kristen, Ashlyn, and potentially a third party mentioned, Jeffrey Linder, who allegedly owned the meth.
Right.
So to turn that mere proximity into legal possession, prosecutors need what the courts call additional circumstances that specifically link the defendant, Ashlyn in this case, exclusively to those drugs.
What kind of additional circumstances would a competent lawyer be looking for or highlighting the absence of to fight that constructive possession claim?
A diligent defense attorney would hammer on the lack of these circumstances. The state would need things like proof she had exclusive control over the specific container the drugs were in, maybe incriminating gestures like trying to hide or destroy the drugs when police arrived, any clear admissions of ownership, yeah, that's my meth, or maybe proof she was the only person who had access to that specific spot. Since the space was shared and the defense could point the finger at another specific person, Linder, as the potential owner, the state's burden of proving Ashlyn's exclusive knowledge and her intent to control that specific meth becomes incredibly difficult to meet beyond a reasonable doubt.
And there's also a subtle but important distinction a good lawyer would draw, right, between admitting to using drugs versus legally possessing the stash found.
Absolutely crucial distinction. The defense could argue, using precedent like Turner v. State, that even if Ashlyn admitted to using drugs at some point, that admission doesn't automatically prove she had current legal possession or control over the specific items discovered during the search. The state has to prove she had dominion and control over that particular meth, that particular syringe, at the time of the search. Without direct proof of that control, not just proximity, not just past use, the state's case on the core possession charge really starts to crumble.
Okay, and finally, there was one more potential argument mentioned, a procedural fairness issue related to the long delay of 14 months between the incident and when Ashlyn was formally charged.
Right, that's a due process claim based on pre-indictment delay.
Yeah.
A 14-month gap between the alleged crime and the formal filing of charges definitely raises a constitutional red flag. Now, it's not an automatic dismissal, but such lengthy delays can significantly prejudice a defendant's ability to mount a defense fate. Memories fade, witnesses disappear, evidence gets lost. A competent defense lawyer absolutely uses this delay. They file a motion demanding dismissal based on constitutional fairness, arguing the delay violated due process. They know that statistically, delays over a year have sometimes led to successful due process dismissals, especially if the defense can show some specific prejudice caused by the wait.
So when you lay it all out, the coerced consent arguments, the expectation of privacy, the Randolph conflict, challenging constructive possession based on more proximity and shared space, and then the due process delay claim, it really shows the sheer complexity and the number of potential winning arguments available here.
It really does.
Yeah.
And it highlights this shocking contrast, doesn't it? On one hand, you have this arsenal of robust, potentially case-dismissing constitutional arguments. On the other hand, you have the retained attorney who started things off by making a fundamental error about the charge itself, then delayed crucial bond motions, and in doing so, fundamentally jeopardized his ability to effectively argue all these complex points by tanking his own credibility right from the start.
Yeah.
It shows Szulkowski really failed to meet that high bar of procedural precision and legal knowledge that was absolutely necessary to deploy these complex, liberty-preserving arguments effectively for his client. #outro.
Now Malfeasant's new track.
Where is Wayne Szulkowski? He will be my son's husband. They will wed immediately.
I don't know where that punk's at. Let's do this track.
Wayne Szulkowski in the dark with his eye too tight, trying to fight for his soul, but he lost that fight. Paperwork bleeds, it drips like guilt. Filed the wrong charge, whole motion got killed. Should've read the rule, but he read it wrong. Now she's sitting in a cell humming freedom song. You fumbled the ball when the stakes were high. Now the truth got cupped while you testified. IRAS couldn't count the aftermath. He forgot to assess. The judge got vexed. Turned a human being to a data set next. He fumbled the motion, the plea fell flat. My girl could've walked, now she's sitting where she sat. Wayne read the code like it's gospel wrong. Now the courthouse hums a name in a song. Wayne, you fumbled the motion. Wayne, you drowned the notion. You misquoted the charge, now she locked in chains, while your briefcase drips with procedural stains. Abuse of discretion, that's the call they made. You buried her rights in the law you played. Could've been out with me, breathing clean. Now the docket got her dreams in quarantine. Evidence suppressed, now you botched that test. Didn't stand your ground, left her unaddressed. Courts don't sleep, they record your sin. Every docket line is where you've been. Wayne, the gavel ain't a game to lose. You wear the suit, but you scuffed the shoes. He fumbled the motion, the plea fell flat. My girl could've walked, now she's sitting where she sat. We read the code like it's gospel wrong. Now the courthouse hums a name in a song. Wayne, you fumbled the motion. Wayne, you drowned the notion. No IRAS score, no fair fight. Just blindfolded skills in the dead of night. Philip got a bond too high to reach, and Ashlyn got a ghost for a legal speech. You could've freed her with a page and pen, but you fumbled truth like it slipped again. Now I'm haunted by a courtroom's grin, where the law was lost and the lies begin. Wayne.